Yay, I think we can start now. Welcome. Welcome, everyone.
Hey, folks. Thank you. Obviously, we are living in a whole new pandemic world. Every one of us are trying out new platforms. So thank you for the patience as we got everything up and running. And I certainly want to extend a thank you to Alt Legal, who did their best to have this conference in Brooklyn, which would have been fun for everybody. But it's really nice to be able to speak to people, at least virtually.
Yeah.
So with that, why don't we go to the next slide so we can actually see who we're talking to here. So I'll turn it over to my co-presenter to let her steal the mic first.
Hi, everyone. Welcome to our webinar. We hope that you leave today with some great information on licensing and how you can help your clients or maybe even yourself. My name is Stephanie Podeck. I'm an attorney who focuses on licensing and brand protection. So this is my second career. And before becoming an attorney, I worked in the toy industry on the business side. And I did everything from start to finish: marketing, sales, licensing, safety issues, went overseas to the factories in China. And we did a lot of licensed goods. So if you ever saw Pizza Hut or Burger King Play Food, Wizard of Oz dolls, that was us. And we actually even did licensing for Sesame Street, and I had to be Elmo. So my picture isn't as exciting as Chris's, but I got to play Elmo in a buyer's office, a Toys R Us buyer's office. We were doing talking shopping carts and strollers. And one of our items was, we didn't have the box, so we went into the buyer's office and we were trying to sell it. And he says, "Well, how can I hear it?" So I had to put on my Elmo voice, and this is for Bree when she watches this. So I had to say, "Oh, what does he say?" Elmo, he says, "Ha ha ha! Elmo's hungry. Elmo left to shop. Ha 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 ha." Anyway, so I have a lot of business experience and a lot of contacts in licensing, and that's where I love to spend my time. So thank you for being here. And now I throw it over to Chris.
Hey, you're not going to get any impressions from me. I am just kind of a rank and file attorney, but I've been doing this for a little while. I fell backwards into trademark law. This isn't where I intended to be, but it's a place that I'm very glad that I ended up. The photo that I put up here is intended to at least be a little bit funny, but it shows a couple of things. One is that I'm incredibly tall, so I'm about 7 feet tall. I assure you, this is far more impressive in person than it is when we do a webinar. But we still appreciate everyone being here. The other one is the danger of what happens when you have non-marketers trying to put together and create a mascot. So I am standing next to T. Markey. This was the U.S. Patent and Trademark Office's mascot that they rolled out back in 2007. More important part of this photo is that T. Markey is currently being worn, or in that photo was being worn by the woman who is now my wife. So she is certainly one who is willing to debase herself for silly photos and also for marrying me. But my wife happens to still be at the trademark office. She is on the policy side where she deals with the ID class issues. But a fun photo, just to give a little bit of street cred for me with trademarks here. My practice has been varied. After a couple of years at the trademark office, I moved over to a big law firm. So I was with Voorhees, Sater, Seymour, and Pease in our Washington, D.C. office, where I spent about 6 to 7 years. The majority of my practice there was prosecution and a fair amount of litigation, search and clearance. But we had a bunch of clients that did licensing. After about 6 or 7 years, at a law firm, I realized I couldn't take it any longer. I was losing my mind, and we'd also just had our first child. And so I transitioned to an in-house role. And I went to Payless Shoe Source, which is located in Topeka, Kansas. So big cultural change, but also a big change in the practice. Payless, in spite of the jokes that can be made about it, which are many, had a huge licensing practice. And so there we were really the licensee, although we also operated as a franchise, which is a whole different discussion that we're not going to get into really today. But we were the licensee for some of the big brands: Disney, Marvel, Star Wars, Nickelodeon. But we also had some unusual licenses that came through different things that we'll talk about a little bit, but came through litigation in the context of American Eagle. And then also came through an asset divestiture in the context of Airwalk. About 2 years ago, I transitioned over to Capital One, where I am assistant general counsel, and I've got pretty much all the soft IP. So my boss and her team handles the whole patent portfolio. I've got trademark and copyright. Capital One has something of a licensing practice. We license our mark to many of the entities that we work with. So to the extent that we lend anyone money, oftentimes they want to highlight that affiliation on their website, and so we do licensing that way. We also have some partnership cards that we work with. But we also do work with big entertainment folks, so Sam Jackson, Charles Barkley, and there are some there's some licensing issues that do come up in those contracts. So that's who we are, and we spent some time talking about that. So what you're probably waiting on is, what are we here for? And so this is just intended to give you a little kind of classic roadmap of where we're going to be going today. We're going to try to follow this really in the order that licenses do come up. So kind of the philosophical question of why are we licensing? What are we doing here? And then walking through kind of how you identify folks that you're going to partner with, the difference between the legal and the business side, some of the important terms, and then what goes into trying to make a successful license, maintaining the relationship, and what we can do there. At the very end, we've just got a handful of resources that we'll share with you. And I guess the one housekeeping note, I'm kind of embarrassed to even say this, I believe that you all are able to ask us questions during the presentation. I think those come through the chat, but our intent is to have some time at the end of the presentation. So to the extent you want to play Stump the Speaker at the end of the presentation, we welcome that. If there are burning questions that we can try to address for you, you may be able to direct them to us. You may have to go through an legal person. I'm sure somebody is going to tell you the proper way to do it, and I apologize for being vague on that. Okay, awkwardness out of the way. Let's turn to the presentation here. And so let's start with this. Stephanie, why would I ever want to license something?
Oh my, so, well, we're going to go through that in a second, but generally, let's talk about what is a license. A license is having something that you grant rights to another to use. So here we're just talking about trademark or copyright. We can add in patent, software. There's so many other things that, if you have some sort of trade secret or proprietary right, you can monetize it with a third party. And that agreement is the license agreement. I think the main thing that we're going to focus on, throughout the theme will be control. Because when you have intellectual property, let's say trademark, you definitely want, you need, in order to keep your rights, you have to have some sort of control. So, and I'm not sure if this, or we'll bring it up later as well. Otherwise, the other party can say it's a naked license and take the rights from you, or the licensor, if it's your client. So that's the start of it. Chris, you want to take over what the licenses do?
Sure. Yeah, I told this before. I will also show my age, but anytime I think about licenses, the word control is certainly the most important. The first thing that jumps into my mind is Janet Jackson. So I'm a child of the 80s, and so I very much recall Janet, Miss Jackson, if you're nasty, and everything that she was able to bring to the table. So a lot of fun to think about it that way, and hopefully it sticks in everyone else's mind now when they see the word license. I think of licenses as a relationship between two parties. So, of course, it's one who's in the context we're discussing, it's one that is providing the intellectual property and one that is generally going to be providing some sort of product. So I think here there are some kind of classic economic terms that we've got, but it's a resource allocation. We're sharing the burden. So oftentimes the IP creator is somebody who's really creative. Where I used to work at Payless, we were really good at making shoes. Really had a phenomenal supply chain. We were able to move shoes from China or Vietnam to the United States in huge, huge, huge quantities. What we weren't able to do was create characters, right? So we needed Disney, Marvel, Star Wars. What we weren't able to do was create established brands. Airwalk being another example of that. So it was a skate shoe in the 80s, meant different things at different times, but it came with a lot of credibility. So what we were able to do there is allocate resources. We were the shoe folks. We were a very experienced party in putting together shoes and doing handbags, a handful of other things. What we weren't so good at was figuring out what should go on the shoes, on the different products. So there, it was a relationship between two different parties. Oftentimes, what you're looking for on the creator side is to be able to expand their reach. And so, for instance, taking something from a book and actually putting in, licensing it to be a toy or whatever you want it to be. And I think we put it down at the bottom, but ultimately we're in business to generate revenue, right? I mean, we're trying to sell stuff. And so this is an opportunity for the folks who can create and the folks who can build to actually come together and kind of as one and actually forge a relationship going forward. Kind of anything to add on that one, Stephanie?
Yeah, no, I think that's good, and it'll dovetail perfectly into the next slide, which is basically identifying the assets and figuring out how to generate revenue. So
yeah. So here we are. So why don't we talk? So Stephanie, you've been more on the creator side than I have. So why don't you talk a little bit about how you do find the assets that you'd like to license?
Okay, so yeah, I think in terms of what Chris was talking about a moment ago, it's true, especially nowadays. You have to figure out. It's much harder, I think. It's easier and harder. When I was in toys, and we would create an order for Toys R Us, it would be thousands and thousands of pieces. I think now, there's so much more saturation of opportunities and choices that it's harder to kind of, make as big a splash. So what's happening now is brand owners, creators are trying to find partners to help, as Chris was saying, extend the brand. It'll generate revenue. It'll create, more of an opportunity. So if you're the creator and you've come up with, let's say, a property, a cartoon property, an animated property, you sit and you've created something, and then as the attorney, you go in and you help them. What have you created? Let's try to identify the assets. So you take a look at each aspect, whether it's, something that is the name available, then of course you want to talk about filing a trademark, and then the different classes in which they'll be, hoping to monetize. So whether it's toys or animation or an app or shoes or something like that. So it's important to identify what's there. So you want to look at any brand names, make sure that, if they're available, you want to talk about trademarking them. Any copyrights, so if there are characters, it has to be original. If it's original, they can protect it. And this is another opportunity also for you to talk to the creator. If there's nothing there, if it's a, generic name, Coffee for Coffee, then it's an opportunity to advise them that this is the time. Well, you may not have something so protectable. Someone wants to license something protectable, all things being equal. If I come with protected intellectual property for an animated property or series, and Chris came and he didn't have anything protected and they weren't sure, all things being equal, they'd probably go with me because I'd have some intellectual property protection. So the identifying is the core, from where to launch.
Stephanie, kind of in connection with that, so I think our practices have been a little bit different. I've been oftentimes kind of with the bigger companies.
Yeah.
But what's the calculus that goes into advising some of the some smaller clients? If money is going to be an issue, right? They don't have a ton of money to spend on registering right away. Where do you usually tell them is a good spot to spend, or kind of how to think about these issues?
So that's a great question. I think it depends on what their goals are. So let's say it's they've come up with a really cute name and a really cute product, and then they have characters. So maybe you have a patent, a trademark, and some copyrights. If it really is a matter of where should they spend their money, it depends who they're going to talk to. If it's something really unique, and their product may actually get that patent protection, not to throw in patents, but let's say wherever they have the best bang for the buck, that's where they should think about protection. Because when you're going to a third party, what's easily stolen? What other elements are you really worried about? If you have a great name and you got the domain name as well, maybe it's the trademark. Copyrights exist once they're put in fixed form. So maybe that's something that you can do after the fact. It really just depends. So I think it's important to know the issues and then be able to discuss it with the creators and the property owners.
Yeah, I appreciate you saying every bit of that. The side that I've been on a little bit more is on the identifying partner side, and this is something, just the concept of licensing is kind of a funny one, where by nature you've got somebody who's created something, and then you've got to go find somebody who can actually build something, and finding someone who's actually looking to build something and can actually do that, take on that burden, is often a tough one. So we want to just throw out kind of some of the practical spots where you actually do that. I mean, it's kind of, sure, you can put an ad out on Craigslist and say, hey, I've got a thing I want to license. I don't know that you're going to find too many folks there. Kind of the bigger ones, there is, and Stephanie, you'll need to remind me, the big licensing expo in Las Vegas. These are spots where you can kind of play matchmaker, and folks are actually coming together to look for properties to license, which is a big thing right now. We highlighted a handful of the considerations as you're looking for a partner. Oftentimes, the reputation is going to be the biggest one. And again, there are plenty of jokes we made about Payless, but ultimately we made inexpensive shoes, and we made a lot of them. For a long time, up until the second bankruptcy, we had a pretty good reputation for being able to do that. And so we were able to pull in a lot of the really good licenses, and just build those relationships over time. But this is so if you're just out of the gate, and I see in the chat now there were several RIP messages about Payless. It was fun. I assure you, it was a very fun place. But if so the calculus when you're starting out versus when you're an more established business. Stephanie, for for a young up and coming, somebody who's just written a book, as opposed to just how would they go about finding somebody that they can license to?
Yeah,
they've got characters out of a book, I should say.
That's a lot harder. So that's something, maybe they have connections. Try to make as many friends as you can. Maybe again, after the intellectual property is protected, maybe put it out on social media, try a Kickstarter. Actually, one of the questions I wanted to ask you, Chris, was when you're looking for partners or licenses. So when you go to the expos, do you work? How do you work? Like, how do you acquire the licenses? Is it third parties, you?
Yeah, so it's worked two different ways. So with Payless, these were a lot more direct relationships. So with Payless, what we were looking for were established properties, because when we were going out to make shoes or handbags, we were making a literal boatload of them. Right, we're making hundreds of thousands of shoes at a time, and so we wanted to make sure that those were gonna sell. Strangely, it's a little bit different at Capital One. So at Capital, and I'm sorry, what did we actually do? We would go in and have meetings with the folks at the licensing expo. Yeah. Oftentimes what we do is kind of do a preliminary license to allow us to do a test run of shoes, see if those were successful, and then actually go for a much larger deal. And so it was kind of a two-step. Capital One, again, is a little bit of a different setup, but oftentimes what everyone is looking for now, and this is kind of license adjacent, but is the ability to work with the influencers. And so there, we're trying to get our name out, but kind of in a sly way. We don't want to beat people over the head with the fact that Capital One is promoting something. So, for instance, this morning we do a lot of work with chefs. That's one of the areas that we've identified where we can really get the brand out. And they're kind of licensing us the ability to use their names in some of our marketing. And so we're a lot more concerned with reputational risk than we really are with any sort of IP issues. Yeah. The chefs oftentimes aren't going to have their names or their restaurants registered. So we're really concerned with, hey, are they promoting a lifestyle that would be harmful to Capital One, which thankfully they normally are not. I did want to just skip down and talk a little bit about what attorneys can do here before we go to the next slide. And so kind of our client sheet and then what the attorneys can do. In a certain sense, I think these are two sides of the same coin as we've discussed. But I think attorneys often have a unique set of eyes in identifying the assets. And Stephanie, maybe you could hit on that a little bit more as well.
Oh, so yeah, I mean, just when you're sitting, to tie these together, it's true. The attorneys have a real opportunity to sit with the client and explain, okay, we'll have a better understanding of what goes into the contracts. And, the legal terms are sometimes different than the business people understand. So somehow we have to kind of bring it together and marry it. So I think creating a client sheet or a deal memo, so where you have the opportunity to kind of list all the basic bullet points of what that license should have. And, and then in terms of what else the attorney can do, again, identify as first, and then go to find the third parties, and then try to figure out ideally what you would want in the deal. And, to Chris's point earlier, it depends, because I've worked, with some of the bigger companies, on those licenses. If you work with a big company, don't expect too many points where you can negotiate or modify anything. But where you have leverage, you might be able to make a difference. And of course, sometimes your client may really be unable to fulfill the contract, and that's huge, where the attorney can come in and kind of just advise them. It could save them from going into bankruptcy, because someone goes into a bad contract. I had someone, there was a contract, and there was an advance guarantee, just in advance of $100,000, not to be offset by royalties. And, I try to explain to the client, well, that means you have to give them $100,000. And they didn't have that. And it would have bankrupted them. And it was, one of those things where, the contract, they said one thing. I said, no, I'm reading it for you. I'm protecting you. This is, it's an opportunity to save them.
And there we go. It is a wonderful lead-in to the next meat of what we're going to talk about here. And this is when we actually start negotiating. So now we've moved beyond the point where we're playing matchmaker. So presumably you found somebody at your licensing expo or through your social media exploits, and all of a sudden we've got parties on each side of the deal. So somebody who's created something and somebody who wants to build something for us. So Stephanie and I, actually, leading into this, we have slightly different takes on the agreements themselves. But I think the first bullet point almost seems silly to have here, but the license should be in writing. Again, it sounds kind of stupid. Hey, we're a whole bunch of attorneys. We're sitting here at a licensing or at a trademark discussion, and we're talking about licensing. Of course, there's going to be a license in writing. Stephanie, is a license the same thing as a term sheet or a deal memo?
Oh my goodness. Well, if you're not careful, it might be. So yes, you absolutely need to make sure that the deal memo, by the way, I've seen deal memos that say, okay, once we sign this, there's an agreement and we'll figure it out afterwards. And you may not be able to figure it out afterwards, so it gets ugly. So you really want to keep them separate. The deal memo should definitely have all the agreed to terms, the negotiated terms, but again, depending on the situation, you may want to make sure that the deal memo isn't binding until an actual license agreement is put in writing. And the writing is huge, because even, again, sometimes you're only as good as enforcement sometimes with contracts. But if you need it and you have to go in front of a judge, you absolutely want that signed contract to help support you.
Yeah, I share every one of those thoughts, and these are some of these. Again, we're trying to just highlight different things that you may see for everybody listening. Highlight different things that you may see in your practice, because it sounds crazy, right? I mean, no business person is ever just going to do a handshake deal until you get that one, and then all of a sudden you've got the handshake deal that comes through just the deal memo or whatever terms that they think they've agreed to, with the belief that they'll go to a larger contract down the road, and things happen. People leave the company. Some other concern comes up, and then all of a sudden you're stuck with a document that doesn't really spell out all the terms that we're going to talk about on the next slide. But Stephanie is spot on. Having the agreement in writing is paramount. My experience on this is that a lot of the license agreements you see are massive. And I don't know if this does it for you, but we're talking 60, 90, 100 pages, and that is helpful to attorneys, because that's what we do. We look at agreements, right, and we pore over words, and this is what we do. I don't always find that that's so helpful to the client. And so here, as you're going into the negotiation, I think one of the really important things to do is ensure that your client has taken a look at absolutely everything, which they're not going to, right? Like every email you're going to send them, it says, please review section 6, 12, and 23, make sure you're okay with those. what you really need to do is pull these material terms out. So that's kind of the second bullet, or I don't know, the second sub bullet that we've got under the first bullet to make that as confusing as possible there. But having the material terms separate as a reference document is something that I found can be incredibly helpful to clients as they go forward. They need to know, well, the important term, you're not going to jump ahead, but they really need to know some important terms, which often are as simple as what are the properties and what's the money. Now, there's some other stuff that we'll get into there. But overall, the negotiation oftentimes is done by the attorneys. So two business people to get together at a conference. They say, great, we're going to make a deal. Then all of a sudden, they throw the contracts over to the attorneys. And this is to say that then we take over. Yeah. Hopefully, we're keeping our clients involved. But then I generally believe that the relationship takes over after that. Oftentimes the attorney, now Stephanie, your practice may be different, but oftentimes the attorneys don't get re-involved until there is some sort of breakdown in the relationship, which is a dangerous spot to be. You don't, hopefully you're engaged throughout. You can identify some of the issues, and we'll get into a few of those in another couple slides. But the other one, Stephanie, as long as we're talking about how these negotiations go, if we're negotiating with, let's say we're working with a big company. So because we would be, depending on which side of the fence we're on, whether you're trying to license your property to Payless, or you're Payless and you're trying to pull in a property from somebody else, what's going to happen with the battle of the forms? How do you usually see this one going? So parties are oftentimes going to have their prepared form that they're going to throw across the table to you and say, thanks, go ahead and sign this one. We'd love to do a deal, just need your signature here.
Yeah. So yeah, generally the bigger company usually wins their form because they're familiar with it. What I love to do though is really try to communicate with my clients just on a basic level about what they're signing and what, because I've looked at enough of these so many times that I see when things look unusual, and then we have a conversation. And I just explain it because I think at the end of the day, they have to agree to it. So this, that a lot of times, the other side will say, just sign it. And sometimes clients do. There's not much, but I just feel that if I advise them of what they're getting into, it's their decision ultimately. They're the ones taking the risk, not me. So I just feel I should, discuss with them. But yes, one of the first things, if it's a smaller company I'm working with, depending on which side, I'll say, well, okay, they're probably not going to sign our agreement. We're going to have to take a look at theirs and see how offensive it may be or burdensome actually is the better word.
Yeah, I guess I do like the sound of burdensome rather than offensive, but it is so it's a difficult one. When the form comes across, what I have found is, just like you said, it is the party with the greater leverage is the one whose form is usually going to win out. Yeah. And then at that point, I think having some familiarity with the actual terms, which I promise you we're getting to in the next slide, really becomes important, because you want to know the ones that are actually worth spending your time on versus the ones that that there's just no way to get around, and what you can do about those. Again, some of these things, until you really get involved in them, you don't realize kind of how important they can be. I am generally not, I don't find venue discussions to be particularly enlightening. Oftentimes what's going to happen is the bigger party is going to say, hey, we're going to have the choice of law be, it's almost always New York because that's where we are. Smaller company is going to say, no, we really need it to be, our home state. And then the parties ultimately kind of defer to Delaware or, whatever they do, California. There are the various classic ones. There's not generally a reason to fight over that a ton. But the thing that I have learned over my career is that those things actually can become important. Because if you end up in litigation, it's not the lawyer. The lawyers are totally fine, right? I mean, we love flying around and taking depositions and doing that stuff. But the business disruption that comes from it is massive. And when you have to prep one of your business people to go take a depo, take a pick in New York or whatever, Montana, wherever you end up being, those are the things that really become problematic. So I'm kind of standing on both sides of the fence here, but I'm saying, you want to know the terms that you can negotiate over, but you also want to know their relative importance.
Yeah, no, that's a fair point, because even, when, and you make a great point, it's, you really want to think about the disruption to the business, because when I was in toys, we had to sue someone and they were based in Canada. And, I took a nice little vacation to Toronto for a few weeks, again, not as an attorney, but I was sitting there being deposed. And, it's just, it's emotionally draining. Financially draining. It's, and it is definitely a disruptor. So again, something to advise your clients and to keep on top of. Good point, Craig.
Yeah, no, these things do come up from time to time. All right, so without further ado, let's start looking at some of the important terms that we find in these agreements. So again, when we're looking at some of the big ones, but whether you look at a form agreement, a particular company's agreement, many of these terms are going to be ones that are at least going to be negotiated over. And I actually see. So yeah. There was one big mistake on this slide.
I didn't even realize it just now.
So we're going to leave the bankruptcy considerations alone because apparently there's a case citation. So apologies to our viewers here, but we will do our best to touch on everything else and clean that one up as we distribute all the course materials. But what we've done is tried to pull together the ones that we find are often. Okay, and so we did have so before we get to the important terms, why don't we touch on a question that just came in? How does one learn how to do that as a newbie with clients who are used to making oral agreements? So Stephanie, I think the question that's being framed is, hey, we've got a client. They have created something and they are used to, in their line of business, just making oral agreements. What do we have to do to coach them into transitioning stuff to paper and really the importance of the agreement itself?
Wow, scary stories. I mean, I think it's really, ask the questions. What would happen? And I'll use partnership, but it's the same thing. When two people are like, oh, we're just going to work together. We've been friends for a long time, and I say, oh, that's really great, until it's not. And then what would happen if? And wouldn't it be better? And maybe you could save the friendship, or maybe you can save the relationship, or maybe you can save the deal, if you just have those discussions up front and negotiate the points up front. I think that's super important.
Yeah, I think that's a good one. The other one that I add on that one is oftentimes, so business people think about things in a very different way than attorneys do. For sure. And I tell the story periodically, but the way we as attorneys are trained to think when we come through law school, it works better when I'm in person, but we think of things vertically. So we write Word documents, we write emails, in a way that goes from top to bottom. What I found is business people, they often think about things horizontally. There we go, horizontally. They prepare slide decks, they put together spreadsheets, and this is the way that they can communicate. So when you've got, what I try to do, and what I really pride myself on doing, is speaking a language that my clients can understand. They don't want to hear case cites, which is precisely why Stephanie and I left the case cite out on this bankruptcy thing, because we knew no one. I'm joking, of course. That was a mistake. But they don't want to hear case cites. They don't want to hear us talk about res judicata. What they want is, listen, explain to me like I'm a normal person. Tell me why I should enter into this agreement, and then make the agreement something that I can read. Make the agreement something that I can read. Or if we're working off a form, you, lawyer, what you're being paid for is to communicate to me what this clause means.
Yeah.
Tell it to me in 3 sentences in English that don't include whereas or herein. So that's oftentimes what I think is important to be able to explain to a new client. It's really difficult to do, and it takes time to kind of improve your patter until you just have to go around the block a few times.
Yeah. And Melissa put a good point in the chat too. She reminds them that everything looks great up front, but the contract is for when things go south. And absolutely. Yeah. Absolutely.
So with a few of those, and again, please keep coming with the questions anytime they pop in. Stephanie, do you have a favorite license term here that you want to take a crack at first?
The favorite one? Oh my goodness.
Or the most important. Well, why don't we talk about the most important one? What are we getting here? So what is the license grant? What's going on there?
Oh, so with the license grant, you're basically, let's say, for example, you're representing the brand owner. So you're working on a contract, you're working with a third party, and you're discussing. And again, to Chris's point, the business people, we'll be discussing, because if you're going to, so if if Burger King and Pizza Hut came to us, we do toys, we're not going to be licensing shoes. They're not going to say, hey, make our shoes for us. So really that license grant is, what exactly is the property? What is the IP being licensed out? And then what company are you working with? What are they manufacturing? What are their goods or services? And that really is the license grant. I think, we didn't include it in here, but part of that should be distribution channels. So you're granting them the ability to manufacture, market, and sell shoes, for example. Well, where? Will it be to big box stores? Will it be, online or Amazon? There are just different ways to carve out. And a perfect example is Star Wars. So if you see Star Wars, I'm a Star Wars fan. I have purses like crazy. I bring them with me to my trade shows. I love them. But the one level of purse, there's just like a normal Loungefly purse. And then I saw Coach had, they licensed all purses, but it's different tiers of maybe product, So again, you want to be specific in order to protect your client.
Yeah, I think that's spot on. And again, we keep coming back to this. It sounds almost self-explanatory, but knowing what you're getting and what you get to use it on, those are just incredibly important things. And when you're dealing with Disney, Marvel, Star Wars, yes, they are massive, right? I mean, they're the ones, and they are incredibly bureaucratic, where you've got somebody who's responsible for Empire Strikes Back, but not for Return of the Jedi, on shoes, but not on sandals. So they break it out in an incredibly bureaucratic way. Yeah. Probably not going to be the way most people are going to be dealing with stuff.
Correct.
But knowing what you got, where you can use it, where you can sell it, those do really, really come through.
Yeah.
Why don't we? In some ways, we'll keep kind of going down the bullet points here. But why don't you talk a little bit about quality control? So we've hinted at that, with my silly Janet Jackson example. But this is a word that we've used a few times. Why don't you tell us a little bit about quality control and how important that is for the agreements?
Sure. So as a brand owner or working with a brand owner, you definitely want to be thinking about, well, you're giving your baby to someone else to make some product. So you have to make sure that they're representing your brand and your level of reputation, whatever it is that is important to you. So the quality control basically will put in provisions that you as the brand owner have approval rights, that you're able to, make sure that before anything goes out, it's gone through you for the approval. And then again, I think, and Chris and I had discussed this separately, and you can jump in, but quality control may be an unannounced visit to a factory. There's a lot in that contract that you want to make sure as a brand owner you will have some control.
Yeah, the quality. Can you hear me? I kept getting in.
Yes. Yeah.
Okay. I was getting a error message there. So the quality control, the way we approach this at Payless, so on the licensee side, was that the licensor has the ability to ensure that their property appears correct, right? So Disney comes to us and they say, hey, we've got this Cinderella, we want to put this on your shoes. We say, absolutely. We would love nothing more than having a Cinderella on your shoes. But you get to tell us how you use Cinderella. You don't get to tell us how to make shoes. So for instance, if we wanted to have Velcro versus a lace-up shoe, of course it makes a difference for the age range that we're targeting. But they don't get to tell us how many stitches that we need to put into a shoe to make it structurally sound. So the quality control, it is something that's heavily negotiated, or often heavily negotiated over in the context of Payless. Our standard was that the licensor could tell us about the quality, the materials, and the workmanship. So that's all they could do. And this was intended for them to be able to identify how their property appeared on the product itself. We didn't want them to go beyond that and start telling us how to make the shoes. But Stephanie, you hinted at what in some ways is an even more, well, that's probably an overstatement, but what in some ways is an equally important concern, and that is the audit right and the ability for the licensor to come in and take a look at what the licensee has. This is one that, as we were talking, this is one that I didn't really identify how big an issue it is until I actually had to go through it. And so maybe you can talk a little bit about the audit rights as well.
So yeah, I mean, audit rights really it's twofold, right? One is you can go in and audit what the manufacturer is doing, and then of course audit rights for the books. So I think people, it's more likely, depending on how big the company is, but it's more likely that the audit rights that will be pursued will be ones where the licensor will go to the licensee and inspect their books. Well, you've been sending me royalty statements. Were your sales really 100,000, or was it really 200,000 and you're not telling me about it? So again, as a brand owner, you want to be able to go in and look under the hood. What's going on with the books? What's going on with the manufacturing? Was it God, I know it's Kathy Lee. I think Jessica Simpson had the same issue, where they're making clothing, and then of course it was found that some of the items were being made in sweatshops. So that's super important. So when you have those rights, and then you're able to, maybe when you see that, you have the ability to terminate based on something really egregious that you found. So audit rights, again, it does come back to control, Chris. It all comes back to what you have the ability to do in connection with your license.
Yeah, and these ones, so the control aspect is key here, and the audit rights are, so these ones are really challenging because at some level they sound pretty simple, right? Hey, we get to, if there's a problem, we get to come in and take a look, right? Like, it's not going to be a big deal. We're just going to take a look. The problem is that the audit, I mean, it's a crazy thing. All of a sudden, you've got 10 people who show up carrying briefcases, and they start looking through everything. Now, this was in the context of Payless, but I do think it applies to others. During the negotiation of the contracts, you really want to make sure that the business people are speaking to each other. So sometimes the way you track things when you're a small business person or a large company like Payless, they were just tracking things on spreadsheets, right? And so the columns in which we were tracking things, whatever number ordered, the cost, the retail price, how many we sold, whatever it was, those didn't easily line up with some of our licensors, which then creates a ton of work when you need to go back through and actually reconcile how these things are going to come forward. And I see there are a couple questions coming in. We'll hop on those in 1 second here. But making sure that the business people and even their systems can communicate does become really, really important. So we'll go. Why don't we tackle the questions here for a second? So the two of them are plain English. And the question about sample language and concepts. So I'll touch the sample language one for a second. So there are kind of two ways that those come to you. One is that you get the draft contract from the larger entity, which can be incredibly frustrating because I assure you that is not going to be in plain English. The other one is, frankly, Google could be your friend here, and you can find it. And I'm just speaking from kind of like a free approach. It could well be that you've got, if you've got access to ABA, they've got form licenses. If you've got access to some of your local bar associations, they may well have a form library as well that you can use. I'll do my 2 seconds on transitioning to plain English. It is really hard. Most of these form contracts are drafted with really long paragraphs that down in the middle have X, Y, and Z. So what I try to do, I truly try to sit down and chart these things out. So I'll take the language and just put it in a word processor and try to break it out sentence by sentence so that such that each clause kind of stands on its own. That's the way I do it. And then I go back through. So I'm sorry. So what I'm saying is I could block and copy something, paste it into a Word document or Google Docs, whatever it is you use, and then go through and break it out sentence by sentence. And then I work on taking out the legalese. I personally can't stand it when I see herein or whereas. I'm also crazy and I'm a single space after a period person, so I need to take those out. Otherwise, my eyes can't read the contract. But that's what I have to do. And for any private practitioners who are on there, that is the stuff that's very difficult to bill for. Yeah. Because when you take a contract and you break it down and then provide it back to your client, they don't love spending 3 hours for what they see as 3 sentences of work. But I'm sorry, Stephanie, you want to hit on a few there too?
That's a tough question. I think whatever works, you want to eventually get to a template that or something that depending on your client's situation, right? Because, I'll work with licensors, I'll work with agents, and I'll work with licensees. So it really depends, it's not a one size fits all. Definitely everyone has different concerns, and you want to make sure those are addressed. I really would caution one thing, as with any other area of the law, you really want to be familiar, especially this is a license. One wrong word and someone can lose their IP. It's just, I think just generally you want to be really careful that you do understand everything, or have someone to talk to about it, because this is one of those things where we're not doing ethics or malpractice, but you really do want to be familiar enough, just like with any area of the law, that you've done enough research that you're like, yes, here's what it is, here's what I'm going to explain to you, and feel confident. Right? Yeah, I think that's important. Sorry, go ahead, Chris.
And I think for the folks who are listening in, I think these are awesome questions, and I think there really is a value to add to be able to present things in plain language. That is what most clients are looking for these days.
Correct. That is true. That is true. I think it's is everyone seeing Bree jump in? Hi, Bree.
Hi, everybody. I'm just gonna right there while we're paused. The CLE code for this session. Please take note of this. Write it down. We will ask you for it in our survey. That code is HW6G2. Again, that's H as in handwriting, W as in witness, 6, G as in giraffe, 2 as in the number. All right, thank you so much. Sorry about that interruption. Please continue.
You have to do the Elmo voice.
I can't do an Elmo voice. My voice is already high-pitched, Stephanie. I can't.
Well, and as much as that was pretty good. As much as I know that everyone loves hearing Stephanie and me talk about licenses, I know that CLE code is probably the most important thing for at least half the people on this call.
Yes.
I have the DC bar, which doesn't mandate the CLE, which is bonkers, but what are you going to do? So got lucky on that one.
Yeah.
Hey, let's talk. So as long as we're on the slide, why don't we touch on a couple of different things? One that you talked about in the past. Why don't you talk a little bit about the minimums and guarantees? So to the extent that we're talking about a royalty-bearing license,
sure.
How are the minimums and guarantees? How are those usually structured?
So again, depending on the situation and the license, you can have a minimum or a guarantee, in the deal memo and the contract. So a minimum is basically, okay, I'm licensing. I'll just use it. So Sesame Street on my strollers and shopping carts. What's the minimum amount of royalty that I'm going to generate for CTW, for Sesame Street? So that that's the minimum that I can do. And a guarantee, again, sometimes there's an overlap, because it's usually a minimum guarantee. So if it's 100,000, I'm saying that regardless of whether I sell that much, I'm going to be paying that much. So it's something that the licensor expects to get in terms of revenue, and that's the minimum. And then as the licensee, you're responsible for hitting that minimum, whether or not you you sell sell the goods, the volume, the revenue. You generate that revenue. And in terms of royalty rate, again, there are ways to figure out through industry groups what the typical ranges are, depending on the goods or services. So that's super important.
Yeah, I think that's a good one. I've seen the royalty rates question in different listservs that I'm on as well. There's often just kind of a mystery as to where these come from. And so with the large manufacturers, with the large companies, Disney, Marvel, Star Wars, they know kind of the numbers that they're going to be able to get. So they've got it down to pretty much a science. But this one, again, this one's a difficult one, and it does deal with the risk allocation. So how much, it can be risky for the licensor to start working with a new company. So oftentimes they want to see that the company is willing to put their money where their mouth is. But it can also be very risky for a smaller company if they're projecting that they're going to be able to make a certain amount of money on something, whether they can actually come through with that. I think that's super helpful. I wanted to just touch on one that is kind of strange, that seems like it's on there, but the parties. So actually switching over to the right column here. This is a surprisingly important one, particularly once you start getting into holding companies and kind of where the properties are coming from and who you're going to be working with. So I think that this applies to both the parties themselves. So for instance, who is doing the licensing and who is making the product. So to ensure that you've got the proper entities in there, oftentimes that stuff can be cleaned up. But I did have a really, really bad scenario where there were two parties on the, I'm trying to get my hand in the screen there, but two parties on the licensor side and only one party on the licensee side. And that became a real problem because then you didn't know to whom you were beholden. So where were you paying? Who was getting the money? What happens if there's a dispute between those two parties? But in addition to the corporate entities themselves, I think it's really important to spell out who's going to be responsible for stuff. So if we're doing the quality control, is there an email address that we're sending it to? Is that email address just approvals at stephanie.com? Or do we have the name of a person who we can actually get on the phone? Oftentimes it can be difficult to get that name, but to the extent that you have somebody you're working with and that it's spelled out in the contract, I've found that can be something super, super helpful, which again, it seems so simple. Hey, we're just going to have the parties in there, like we can bang this one out. But it can become really difficult in practice if you don't have a real person that you're working with and it's just a mailbox. You never know if you can get them on the horn if something goes south.
Yeah, I think that's a really good point, and I think it comes back to, again, knowing what needs to be in these contracts, knowing again, a lot of what we're talking about is from our experiences. So these are cautionary tales that we would be like, oh wait, okay, I'm going to modify this because I know that this may be an issue. Yep. So again, I think it's important. I'm not sure we're going to have time to get through all of these, but I know we have a slide coming up in a little bit.
I was going to say, I know we don't have enough time to get through all of these. So why don't we go to, why don't we try to take our story in a slightly different direction and talk about, so there are all sorts of terms that we just had in there, but what's it take to actually make a successful license? What do we need to be able to have a good relationship here?
Oh, so I mean, I think finding a very good partner that will kind of help you, help you have the same goals, you have the same vision. That's usually the best one. And of course, the product gets out, it's beautiful, it's wonderful, and it's successful, and everyone's making money and everyone's happy.
Yeah, this is, and I mentioned at the beginning that I'm a 7-footer. There is a silly, but it often rings true statement in sports, but that winning is the best deodorant. And I think in this context, often making money is the best deodorant. So to the extent that both parties are making money, often things are going to go just fine.
Yeah.
I think that is also a difficult way to try to run listen, the money should be the end goal, but what I tried to put up, or what we tried to put in here, are that you need to have a partnership. So the parties that need to be communicating, because at time, listen, if you're doing retail products, all of a sudden something happens, right? All of a sudden COVID takes over and people are not getting foot traffic into stores. You need to be able to pick up the phone and actually have some sort of dialogue to change change things, to ensure that as market circumstances change, that you can work with your partner. You may not be able to, right? Yeah. I mean, some of the massive ones, they may just hang up on you and say, "Listen, we signed a contract."
Yeah.
But from experience, I can tell you that when things got, so at Payless, we went through a couple of bankruptcies. When things got bad, even the big licensors, they were willing to work with us based on our history, based on the way things were going. I think so we hinted at the beginning, but what sort of communication would you say you need to have between the lawyer and then the business person?
So, again, I think it's the job of the lawyer to inform the business person what the material contract terms are and what they have to do. And then, I also encourage my clients, same. You want a good relationship with everyone that you're working with. The goal really is, managing I find in almost everything, managing the expectation is huge. And this way, if the expectations are very similar on both sides, there's less of a chance for some sort of dispute. So I agree with you completely. I think it is super important.
Yeah, and I think that's a good one. I would just kind of throw out there from a practice perspective. Listen, every one of us on this call, we are going to negotiate the absolute perfect agreement. There's going to be nothing open to interpretation. I'm positive we're going to get it perfect. But if you don't, a good way to check in is, I don't know how often you talk to your various clients, but if you can just put a tickler up to, reach out to them every 6 months or so. Hey, your royalty statement was due last week. Just want to be sure, are things cool? This is a good way. You don't need to bill them, or you can, depending on your relationship. But it's a good way. When I was back in private practice, it was a good way to just be able to reach out. Hey, anything else that y'all are working on at the same time?
Yeah.
Right. So from the lawyer perspective, it's a chance to keep talking to your business person.
Yeah.
Obviously, you hope that the two of them are talking, but it's entirely possible that you send that email and they say, "Oh, yeah, I forgot to mention to you. We our license agreement was just for Mickey Mouse. We also started doing Goofy." I mean, I know it's not going to happen with Disney, but to insert whatever properties your client is part of, they will just do a handshake deal on the side, right? They'll exchange emails and say, let's amend this agreement. And oftentimes it's through no fault of anybody's. They don't think to engage with the attorney. Yes. So again, hopefully your relationship is always perfect, but mine certainly wasn't with my clients.
No, that's a really good point. Keeping in close communication, or just the check-in is a great idea.
Yeah,
especially for the inspections and audits, because that's where you go, hey, don't forget, especially if they're not used to doing that in their regular business.
Yeah, it's when you transition from being a creative to actually being a licensing entity, it is different. A lot of these people they did stuff because they were great at writing books or drawing pictures or whatever it was. But the business part, not to demean anybody, but oftentimes the business part isn't what they set out to do. They got an MFA as opposed to an MBA for a good reason. That often happens. All right, as we continue to creep closer and closer to time, why don't we talk a little bit about what happens when things go south? What problems do you see with licensing and how things fall apart?
Okay.
Oops. Thank you for switching that.
No.
Thank you. I tapped the wrong button.
I think there are a lot of pitfalls that can happen, and I'm hoping we get to the next slide, because ending the relationship and termination and what you can put in your contract is also, we could have a whole webinar on that one. Let me see here. Hang on, sorry. So we're looking at again, I think we discussed some of it in terms of the finances. Chris, jump in, but I think it's you want to make sure that the clients your client has the expectation, because if something falls short, if let's say you have that minimum guarantee of $100,000 and it's not performing, then that might be a pitfall, and the monetary issues aren't being met. So what are we going to do then? In terms of again, deal memo, term sheets, there could be deficiencies in everything here, including not assessing the risk and selecting the wrong partner. They're just it can be a nightmare, and I think you have good stories on this one.
For good and bad, I do. I think hey, until something goes wrong, you don't have the experience, but then you're able to kind of build from it. I think the first and the final bullets are the two that are often the most important. So the money, is the money coming in, and then also the quality control, right? Whether regardless of which side of the fence you're on. Is the licensor properly exerting control over its properties? Kind of, in spite of what we talked about at the beginning of the sanctity of the agreement, oftentimes things just happen, right? Like there's a mistake that is made, and somebody improperly cut a check for the royalty payment, improperly computed something, or somebody forgot to submit something for approval. These things happen. If you're in a relationship, let's not touch on that right now. But if you're in a business relationship between two parties, you're often going to have some place where there's a hiccup. These can go bad in a hurry if you try to cover them up. So what I have always found, again, this is not profound advice, to the extent you can come clean and just say, listen, we blew it. Last month's royalty was supposed to be, it was supposed to be 25,000. We inadvertently computed it at 18,000. We're going to try to make good this month, or even if there's a reason for it, right? I mean, hey, or we didn't have enough money coming in. We weren't able to cut you that. We're going to try to make it up next month. Those are the ones that you want to get out ahead of. Similarly, if you've got a quality control issue, hey, whoops, we sold 10,000 of these widgets, and we completely forgot to get them out to you. They were in line with our standard approval process. It was everything that we had done. It's a new person, kind of whatever the story is that you need to tell. Those are the ones that you want to get out ahead of before they really lead to the end of the relationship. Yeah. Again, we are now, of course, coming up real close on time. So why don't we touch real quick on the ending a relationship, and then we'll be able to pretty quickly end our presentation. And
by the way, just to finish your, it comes back to communication. Everything you were just talking about. I think it's super important to be on the same page. So I think part of the contract, and if you're going to be working with your client, ask reasons. Why would I want to terminate this agreement? I think it's so important. As we've been discussing the whole way through, any term can go bad. Is it material enough that you want the permission, the ability to terminate that license or cure, or what is really your concern with that? I think that's important. I'll let you have the last word on this, Chris.
This is a tough one because business people by their nature are optimists. I'm painting with a broad brush here, and lawyers by our nature are generally pessimists. So when business people are getting into these deals, the end of it is not normally the thing that they're worried about, right? Listen, this is going to be the greatest arrangement that has ever occurred in history, right? We're going to make all the money and everyone's going to be happy. Yeah. It stinks to be the attorney who steps in and says, that may be, and we want it to go that way, but there are some things that there are some real things that you need to think about. Generally, kind of in line with the other stuff that we've talked about, the things that become really important as you end a relationship are the money. Kind of where. So how are the final payments going to come in, and how are those going to happen? And then the other one is, how are we going to wind down any product that we've licensed? So if you represent the licensee in one of these scenarios, are we going to be able to sell through the remaining product? Do we have to destroy it? Which, with some of the big licensors, that's actually what they mandate. So when we did the Disney ones, there were certain products that if you didn't sell them, you had to deface them. They did not want those out on the market. That's a huge cost that a company has to take. I mean, so you really need to be wary of that. Yeah. The other one that we had tossed in here is, that we're not going to be able to get into in detail, is whether you want to have automatic renewal rights. So oftentimes these agreements, again, they're intended, the best of intentions. You just say, well, we're going to be making a ton of money. Let's just keep rolling it over year over year over year. Well, that's all fine and good until it rolls over and somebody isn't particularly interested in it. And so I've had situations where business people leave the company. So the people who were champions for a particular license, it's not what the new people wanted anymore. Mm-hmm. And they're kind of stuck with it. And then you're trying to negotiate your way out of it. Tried to squeeze a lot into a short time on that one. Stephanie, final word on ending a relationship before we end our presentation here?
Try to think of it when you're dating, everything is so much easier to talk about than divorce. So it's like that prenup, have that conversation up front. I think the more upfront you can be and manage expectations, the better off you're going to be, your client's going to be, and just their business is going to be.
Wow. That was said with beauty, in spite of it being in the context of divorce. So thank you. So let's just throw up a handful of different resources. It is a good question on finding the sample language and concepts. I believe that we did a form document or a form agreement. I'll need to go back and look. Yeah. These were a handful of blogs that probably, or 3 blogs and a casebook that probably everyone on the call is aware of. Property Intangible is probably the best one relating to licensing. So this is Pam Chestek, who's a practitioner down in North Carolina, but she blogs about who owns property or intellectual property. Oftentimes licensing comes up. TTAB blog, usually in the context of TTAB disputes, but licensing comes up from time to time. Eric Goldman's blog is one. He's a professor at Santa Clara who also wrote the TM case book, which is an open source case book it's got some good references to case law for you in there too. All right.
Yeah.
With that, let's see. How do we do? Great feedback. That must mean we've been here for an hour.
You guys have done amazingly well. Thank you so very much. That was wonderful and enlightening, and we all know so much more about licenses. And you have the license to say it all again if you would like, because we would listen to it again. Okay, so we are out of time. We do have a real quick break. But coming up next at 1 o'clock Eastern, we have building a subscription practice, and when it isn't what it is, maintaining a brand distinctiveness and avoiding genericide. To go to either of those sessions, you'll just go to the schedule page and choose which session to attend and join from there. Thank you so much to both of you, and thank you to everyone for listening. It's been really wonderful and incredibly enlightening.
Thanks for having us. Thank you, Chris. Thank you, everyone, for watching. Appreciate all your help.
Thanks, everybody. Have a great day.
Take care.
Thank you.